Let's shift back to the topic you and I discussed yesterday, which is religious liberty, which is a topic of considerable interest and importance to a great many Americans. In private practice, you wrote an amicus brief in the Santa Fe case for Congressman Steve Largent and J.C. Watts. Could you describe to this committee what that case was about and your representation there?
I will. Of course, Senator Cornyn argued the case as Attorney General for the state of Texas and did an outstanding job. I remember participating in the moot court, as the senator recalled.
It didn't turn out too well, Judge.
You did an excellent job, Senator, as I remember being there. So the case involved prayer before a football game. And the Supreme Court, of course, has had a number of cases on religious expression in schools, and these are always challenging cases and very fact-specific. But there are two principles that the precedents have set forth. One is that school-sponsored prayer at school events is often impermissible, either at the school day, Engel versus Vitale, graduations, Lee versus Weissman. At the same time, when students want to express themselves in some way, T-shirt, clothing, or saying their own prayer, say before a football game or other event, the students want to say a prayer for themselves, or there's an open forum where students are allowed to say whatever they want, and one student chooses to talk about religion or say a prayer. That's generally on the free speech side of the House, freedom of religion side of the House of the Supreme Court precedent, which would protect the religious liberty of the individual in that circumstance. The Santa Fe case came, I think Senator Cornyn would say, Senator Cornyn would say it came on the free speech, freedom of religion side of the House. The Supreme Court thought that the school was too involved, I would say, in the prayer opportunity in that case, and thus attributed the prayer in that case to the school. And the Supreme Court therefore said that the prayer in that case was impermissible. It was a very fact-specific decision, I think, based on how some of the actual prayers had gone down in the school district there. And so it was really in the gray area on the facts between these two principles: freedom of speech and freedom of religion for individuals on the one hand, no school-sponsored prayer on the other, and those two principles are part of the Supreme Court precedent that I think the courts have applied for a long time now.
So what led you to want to take on that representation in the amicus brief?
Well, I think at that time I worked on was asked to work on several cases involving religious liberty and religious speech. I also did a case in the amicus brief in the Good News Club case, and that was a case where a school district allowed use of the gymnasium auditorium area after school for whatever group from the community wanted to use the facility. And they would allow everyone to come in, Boy Scouts, the community, any community group to come in, but they didn't allow religious groups to come in. And that seemed to be discrimination against religion, discrimination against religious people, religious speech. And I was asked to do an amicus brief, which made the point I wrote that made the point that religious people, religious speakers, religious speech is entitled to its place on an equal basis in the public square, including in this case in the school auditorium or gymnasium. The Supreme Court agreed with that principle in that case, stating that discrimination against religion in public facilities and in the nature of what was going on in that case was impermissible and a violation of freedom of speech, freedom of religion, and therefore unconstitutional. Those cases are important, I think, because it's important that to recognize that the Constitution, the First Amendment to the Constitution, as well as many statutes, of course, protect religious liberty in the United States, religious freedom in the United States. And as I've said in some of my opinions, we're all equally American, no matter what religion we are or no religion at all. That means religious speakers and religious people have a right to their place in the public square.